jurisdiction, which means its jurisdiction is derived entirely from various ordinances or statutes. In contrast, the Supreme Court is a court of inherent jurisdiction, which means that it may hear any matter that comes before it, unless the jurisdiction is limited by statute or rules that put that authority to some other court or tribunal. Or to put that another way, it hears cases where the jurisdiction has not been vested in the magistrates' court or some other tribunal, such as the Labour Tribunal. It hears cases at first instance which fall, as I say, outside of the jurisdiction of the magistrates' court. In the Supreme Court, there is no limit to the value of any claim. And the Supreme Court's also a court of superior jurisdiction, which means that it may hear appeals from lower courts and tribunals. So how does this work for choice of courts? Well, the Magistrates' Court is intended for less complicated claims where the parties may be able to deal with matters without the need for legal representation. The practical result of that, as far as you're concerned, is that the presiding magistrate has to explain the procedure and the law to the parties, and the administration staff may be called on by the parties for assistance or guidance. It should be remembered that court personnel, and that includes judges and magistrates, should not give legal advice. Any advice should be limited to the functioning of the court and the administrative procedure. Now, that's fairly important because I see quite a lot that court staff are telling people or advising people on the merits of their claims or how they should present their claims. And that is not a function of the court staff. And as I say, that includes judges and magistrates. We are not here to advise people how they should run their claims or how they should present their claims. In the Supreme Court, there are strict rules of practice which must be followed. And if you fail to follow those strict rules, cost sanctions can be applied by the court. Ultimately, the choice of the court is decided by any statutory jurisdictional provision that there might be, and the value and the complexity of the claim. So dealing first, what are civil claims? Well, a civil claim is any matter or dispute which has to be decided, which is not criminal. And the civil jurisdiction of the Magistrates' Court is set out in section 108 and sets out all the details in which the Magistrates' Court, under that ordinance, has jurisdiction to hear civil claims. That can include breaches of contract, such as debt, whether that's personal debt or commercial debt.
Would you like would you like the contact for the property manager on behalf of? Right. So let me send. I'm gonna WhatsApp you now and give.
Sorry, Mr. Lalbehari. Mr. Lalbehari.
Well, her phone number.
Mr. Lalbehari.
And I could and you could give her a call and just sort of get some clarity as to whatever, because but I know the governor would have had to sign a lease because she's in the premises. So I don't know exactly how they did it, but the governor is at that residence as well.
Have we managed to quieten him?
Go ahead, I muted him.
So yeah, so as I say, breach of contract claims can include such things as debts, be that personal or commercial, credit card debts of that kind of thing, bank debts. Also includes such things as rent claim, landlord and tenant matters, damage to property. Civil claims also include something called torts, and a tort is a civil wrong. And that's a wrong that's been done to somebody that doesn't arise from any contractual obligation. So it can include things like trespass to land, boundary disputes, negligence claims such as damage arising from road traffic accidents, personal injury claims, occupier's liability, where, say, a ladder has fallen off from somebody's property and gone through the window of the neighbouring house, those kinds of claims. Claims in the magistrates' court are limited in value up to $10,000, but there's an overriding proviso that if both parties agree in writing, then the magistrate may hear a matter of any value.
Oh, I didn't know that.
So how do you start a claim? Well, in the magistrates' court, all claims are commenced by the issue of a plaint note. That's just a fairly simple document that you complete with details and basic information as to what the claim is about. In the Supreme Court, all claims are started by an originating procedure. Now, there's a number of those. It could be a writ of summons, an originating summons, an originating motion, an originating petition, and in very certain circumstances, an ex parte originating summons. Now, the kind of process that's used in the Supreme Court will depend on what the type of claim is, what the relief is being sought, and who the opposing parties are. So the type of process that commences a claim in the Supreme Court is set out under the rules. How does a claim progress? Well, in the magistrates' court, the procedure is relatively informal. All that's required of the claim is outline details of what is being claimed and why. They generally put forward in a most basic fashion. The plaint note is usually served by the bailiff, a police officer, or some other process server. And it amounts to a court summons, which requires the defendant to attend before the court at a certain day and time. The effect of that is that once the plaint note is issued from the court, a court date has been set for attendance for the parties. The defendant does not need to indicate whether the claim is defended until the matter comes before the court. In the Supreme Court, it is an entirely different process. The procedure is formal. The defence and claim must be properly pleaded, which sets out all the allegations and all the facts which the parties intend to rely on. The originating process, like a plaint note, is generally served personally, but applications can be made for leave to serve out of the jurisdiction and to serve by substituted service, such as email or advertising in local newspapers. The defendant, once served, has 14 days to file an acknowledgement of service, which indicates whether or not the claim is going to be defended, either in part or in whole. And if the claim is defended, then a formal defence must be filed with the court within 28 days from the date of service of the originating process. So that service period is not curtailed. For example, if the defendant was served on a specific date and within 3 days files his acknowledgement of service, he still has a full 28 days to file his defence. Family claims. Well, family claims under the jurisdiction of the Magistrates' Court arise under a number of ordinances. There is the Domestic Proceedings Ordinance, the Family Law, Guardian Custody and Access to Children Ordinance, the Domestic Violence Ordinance 2015, which I'll make some note about, that didn't come into force until December 2021. And then there's the Children Care and Protection Ordinance. There may well be other ordinances as well that are applicable, but that's as far as I think we need to go for today's presentation. In respect of the Family Law, Guardian Custody and Access to Children Ordinance, the Supreme Court also has jurisdiction under that ordinance, but only where that jurisdiction has arisen because it can act otherwise. For example, within divorce proceedings, or where a child has been made a ward of court in circumstances perhaps where there has been a child abduction or a threatened child abduction. There are two kinds of family law, or two branches of family law, which is private family law and public law. What we're concerned with in the majority, I think, is private family law. So the Domestic Proceedings Ordinance deals with spousal and child maintenance outside of divorce, but only deals with spousal maintenance. So cohabitees could make no claim in relation to the Domestic Proceedings Ordinance. There is a degree of protection afforded within the Domestic Proceedings Ordinance, where orders can be made to prohibit violence against one of the parties, but only again where the parties are party to a marriage or it is against a child of the family. So the Domestic Proceedings Ordinance provides no protection for cohabitees. And the Domestic Proceedings Ordinance also deals with affiliation, which is in essence an application to the court for a declaration that one of the parties is the father to the child. Now, child maintenance can only be awarded under the Domestic Proceedings Ordinance once an affiliation order has been made. So child maintenance, in essence, is only in relation to married couples under the Domestic Proceedings Ordinance, unless the application for an affiliation order is made. The Family Law, Guardianship, Custody and Access to Children Ordinance is a relatively new ordinance and vests, as I said earlier, the jurisdiction in the Magistrates' Court, but there is a concurrent jurisdiction within the Supreme Court if the Supreme Court is already engaged in another way. It deals with custody, access and maintenance to children outside of divorce proceedings. And divorce proceedings are conducted within the Supreme Court under the Matrimonial Causes Ordinance. There is an overlap of the orders that can be made under the Matrimonial Causes Ordinance with the orders that can be made under the Family Law, Guardianship, Custody and Access to Children Ordinance. There is also some degree of protection from harassment under the Family Law, Guardianship, Custody and Access to Children Ordinance. But note that this came into force in October of 2016, and its protective jurisdiction has now been largely superseded by the Domestic Violence Ordinance 2015. The Domestic Violence Ordinance 2015 didn't come into force until December 2021. There was something like a 5-year gap from the passing of that ordinance to it coming into force. The jurisdiction is vested solely in the Magistrates' Court, and its main purpose is to give the court the power to issue protection orders. So who may apply for an order under the Domestic Violence Ordinance? Well, a person, that's male or female or a child, who is or has been in a domestic relationship with the respondent may make an application. What is a domestic relationship then? Well, it's defined as a relationship between an applicant and a respondent in any of the following ways: that they are or were married to each other, including a marriage according to any law, custom or religion. Now, that raises the question is when it says according to any law, whether that's a law of the Turks and Caicos Islands or any law which would include same-sex marriages. I'm not aware that that has so far been tested. The application could be made between parties who have cohabited or who cohabit with each other, so they do not need to be married. Applications can be made from the parents of a child or of persons who have or have had parental responsibility for that child, such as a guardian. So that expands the jurisdiction and brings into applicants cohabitees. Applicants can be family members related by consanguinity, affinity, or adoption. So that's blood relatives can make an application, married people can make an application, and adoptive parents can also make an application against the natural parents, for example. It also includes family members if they would be related by affinity, if they were cohabitees but were able to be married to each other. And it also includes parties who are or were engaged to each other, dating, or in a visiting relationship. Or that they share the same household or residence. So what can be seen from all of that is that the applications for protection orders can be made by a wide range of applicants, rather than those very limited categories that fall under the other ordinances. But in all cases, there must be some form of a personal relationship. Protection orders are not available, for example, against neighbours. So the Domestic Violence Ordinance introduced into the Magistrates' Court the concept of undertakings. And an undertaking can provide for a respondent to an application for a protection order to give an undertaking to the court. An undertaking is a solemn promise to the court that the respondent will not do any of the acts sought to be restrained in the protection order application. And a breach of an undertaking carries the same penalty as a breach of a protection order. So, but there's big benefits of a respondent from giving an undertaking. Firstly, matters can be dealt with more speedily and amicably. Secondly, and importantly, there is no finding of fact against the respondent that he or she has committed any of the acts complained of. And accordingly, a form of undertaking is the same in essence as an order of the court, and a formal document should be signed and sealed by the court, which then records that the undertaking has been given. As I say, a breach of an undertaking carries the same penalties as the breach of a formal court order. The benefit being there has been no finding of fact against the respondent. And then just to bring things on this slideshow presentation to a close, I'll just touch very briefly on public family law. And this broadly mainly falls under the Children Care and Protection Ordinance. And the Children Care and Protection Ordinance provides for the protection of children from abuse and neglect. And it is to ensure that the best interests of the children are given paramount considerations in relation to all matters relating to them. It's aimed at the relationship between the child and its parents or guardian. And it is to provide for children who are in urgent need of care and protection. Protection orders can be made under the Children Care and Protection Ordinance, but they are different from protection orders made under the Domestic Violence Ordinance. They are, in essence, emergency orders required where a child is in need of protection or his or her health and safety is in immediate jeopardy. So the protection order is an emergency protection order issued by the court, usually for a short-term period of time, until the court has time for social services to carry out a full investigation. And these applications are made by social services to the court. They then carry out an investigation, and generally matters will move on to a care order rather than the protection order continuing. So that's the end, as far as I'm concerned, of the slideshow presentation. As I say, the scope for this talk this afternoon was relatively limited, and I rather hope that I can throw the questions out to the floor and that we can move forward in that direction. Are there any questions?
Okay, does anybody have any questions with regards to the presentation, or even if something was not mentioned and touches civil procedure of family procedure? I have a question.
Yes.
You had mentioned in the beginning with when you were dealing with civil plaints, does the magistrate court have jurisdiction to deal with matters like defamation of character?
It does. Yes. If you look at the section 108, defamation claims are incredibly difficult. And one of the bigger problems with defamation claims is that they're generally trialed by jury.
Right. I know in some jurisdictions it's the magistrate court doesn't have jurisdiction because it deals with assessment of damages.
I believe it does have jurisdiction under the just bear with me. Do you find that defamation claims arise frequently?
We have had some persons coming to ask about it, yes.
I mean, the outcome of a defamation claim, I may be wrong because defamation is not coming up under the Magistrates Court ordinance. Defamation claims are generally resolved by way of a retraction or an apology, or relatively minor damages. But they are.
Does magistrate court deal with damages? In relation to defamation of character. I mean, there's no set amount. There's no money amount set to it. So
no, and you'll know that most of the big cases. I think that the most recent one's the Taylor Swift case, where she was awarded $1.
Mm-hmm.
They tend to be cases of principle, and quite difficult to prove. They're also jury trials.
Yeah, that's why I had asked the question, because I was wondering whether or not magistrate court can deal with that, or it has to go to Supreme Court.
It does appear that it goes to the Supreme Court. Just bear with me. I think it's another one of these areas where we have no legislation for it. So there's no, yeah, there's no ordinance. So we tend to fall back on what happens in other jurisdictions and claims under the common law.
Okay.
Ms. Arana, I think it's you that kind of raised the need for this meeting or this presentation today. What are the concerns that are arising that have given rise to that?
I bring it up based on what the staff said. That's why I'm wondering why they don't have any questions, like everything is clear.
Why is everybody so
in terms
quiet?
of claim, you would have to ask them. In terms of the claim, the initiation of a claim and the process that it goes through, it says service by bailiff, police officers, and process servers. So it would be incumbent on the registry staff to know who a bailiff, police officer, process server is.
Right.
Can it be served by any person, or is there provisions that it must be served by a process server, bailiff, or police officer?
No, process can be served by anyone.
Ooh.
The only
By anyone?
limitation, yes, the only limitation is in respect to divorce petitions, which cannot be served by the petitioner.
Oh.
You see, I didn't.
I have a
You
question.
see that?
Ju-
Go ahead.
Afternoon, Justice Grusho, Ms. Benjamin
Afternoon.
here. Yes, sir.
Everybody's hiding without cameras.
I have a question in regards to the time that you have to, in the magistrate's court, that you have to serve the summons on the other party. If, for instance, that you serve it less than 7 days, would that be okay to proceed with the matter if the person shows up in court, the defendant shows up in court?
Yes, any time limits can be waived by the defendant. So they may turn around, they may argue say that they've been short served. If they have, then a new date needs to be fixed. But if they're willing to proceed with it, then there's nothing wrong with that.
Okay, thank you.
Afternoon, Justice
Yep.
Grusho.
Afternoon.
Hi, can you explain the Supreme Court, the commencement, starting with the originating procedure, please?
How do you mean explain it? What's the actual
No,
question?
well,
So-
I missed it when you were doing it before.
Ah,
So I just wanted you to go back over it a little bit for me, please. Thank you.
sure. Do you want me to put the screen back up, or shall I
Yes,
just talk
please.
to it?
Thank you. Thank you.
Let's just see if I can do that. Yeah, so we're this one. So then the magistrates court, all the claims are commenced by a plaint note. In the Supreme Court, claims are commenced by an originating procedure, and it depends on the kind of the claim as to what that originating procedure is. Generally, it will be a writ of summons. If there's an issue to be decided by the court. So if I'm claiming money from you, or I'm saying you were the cause of a road traffic accident and I've suffered personal injury, all of those kinds of claims will be commenced by a writ of summons, which will have either endorsed on it a statement of claim, or a statement of claim will follow. But the majority of the time, the statement of claim will be filed with the writ. And the statement of claim is a detailed document which sets out all of the facts upon which the plaintiff intends to rely, and essentially sets out why they say the defendant was the cause of the problem, or why the defendant owes the money. But there are other kinds of originating processes, such as an originating summons. And you would use an originating summons for something like where you need an answer from the court, but the other party is not necessarily, or there isn't a question to be decided. It's not a dispute, but you need sanction of the court. So, for example, if you default on your bank loan that's secured on your house, and the bank wishes to sell the property, then it will need to make an application to the court for permission to sell by private treaty, for example. it needs the court's permission, but the other side or the house owner really doesn't have a great say, and there's no dispute over this. If there's a dispute as to whether or not the loan is in arrears, then that claim would then be converted into a writ claim and proceed in that way. And then there are other kinds of claims that can be brought by originating motion or originating petition, but they are set out in the rules. So you look at the specific kind of a claim, and then the rule will tell you whether it can be commenced by originating motion or originating petition. I mean, the most common being a divorce, because divorces are always commenced by originating petition. I've put in there ex parte originating summons, but they're used very, very rarely, because they're almost an oxymoron in themselves. How can you have an originating summons which summons somebody to court, but it's ex parte, so there isn't another party to summons? But certain claims can be commenced. Certain very rare claims can be commenced by an ex parte originating summons, but they are widely abused in the Supreme Court with people making applications by way of originating summons, which should be made simply by filing an affidavit and a letter requesting an ex parte hearing.
Okay, thank you. One more question. Could you, I know you mentioned divorce. Could you explain legal separation? Because I know we had a misunderstanding sometime with divorce and legal separation.
Yes, divorce
Thank
and legal separation are two different concepts. They're both begun by the presentation of a petition, but the difference with the legal separation is that the parties remain married, and legal separation will generally only be used in circumstances where there's a religious reason where the parties cannot get divorced. It allows the court essentially to say that the parties are separated and to make certain financial orders, but it doesn't bring to an end all of the financial claims in the same way a divorce petition and a final ancillary relief order in divorce will bring to a conclusion all the financial claims.
Okay.
So judicial separation generally isn't used a great deal.
Right. I'm just gonna ask you if you have ever done any in Providentialis.
I can tell you I've never done any at all in practice. Sorry.
Okay.
I was involved in one. I didn't do it, but I was involved in one. It was an Indian couple, and they judicially separated, as I say, for religious reasons. And the difficulty that what had arisen was that I think it was the husband that was coming back to make a claim against the wife who had done terribly well post-separation. And the financial claims within the legal separation had never been brought to a final conclusion and couldn't be brought to a final conclusion. So he still had a valid claim.
Yeah.
Albeit the longer the time the parties are separated, the less strong that claim is.
The less strong it is?
Yes.
Okay. Thank you.
But as I say, judicial separation are extremely rare. Rather like, I mean, if we're going on, rather like I'm seeing an awful lot of desertion divorce petitions. Less than 2% of divorces in the UK proceed on desertion, and it's something which is very difficult to prove. But I see an awful lot of petitions are put in here on desertion.
Desertion, yes.
On that same note with divorce matters, Justice Bishop, the where persons are divorced and issues of child maintenance is not addressed. Is that possible, or all of that get addressed at the Supreme Court in the divorce proceedings? Or if it doesn't get addressed at the Supreme Court, can they still come to magistrate court and apply for child maintenance even though they have gone through divorce proceedings?
Well, yes, there's the dual jurisdiction of the family law ordinance.
Mm.
So within the matrimonial causes ordinance, the Supreme Court will consider what's going to happen to the children, where they're going to live, what their education is going to be moving forward, and would deal with child maintenance within the divorce proceedings. But any order that's made in respect of a child is never a final order, and it can always be revisited. But there is a dual jurisdiction under the family law ordinance, which allows the magistrates court to deal with child maintenance, and that can be brought to life sometime after the divorce proceedings. So once the matrimonial causes claim has come to a conclusion, I don't see there's any reason why parties couldn't revert back to the magistrates court to deal with child maintenance issues moving forward.
Even if the Supreme Court has already made a decision on child maintenance?
Yes, there's that dual
Okay.
jurisdiction under
Okay.
the family law ordinance.
Okay.
And of course, the Supreme Court will only get involved in child maintenance really within divorce proceedings, because everything else is vested in the magistrates court.
Any other questions?
Ms. Stubbs here.
Um,
I just need just clarify on the last point you touched on, Mr. Grusha, in regards to the dual, in regards to the child support maintenance, whether Supreme Court or Magistrates Court.
Yes.
Okay,
Yeah,
you stated whether the Supreme Court makes an order, they can also have an order in the Magistrates Court as well.
well, it would be the same order. Would it come back
But
to
the
the
Magistrate
Supreme Court?
Mm-hmm.
Go on, sorry.
The reason I asked, because I was told previously that once an order is made in the divorce court, especially in regards to the child support maintenance, they cannot come back to the lower court.
That would be right if it was made under the matrimonial causes ordinance. But I don't see why that would prevent anybody coming back and making a different claim under the family law ordinance, which could then be vested into the magistrates court.
Okay.
just as crucial, what about spousal support? Does the wife get spousal support if she asks for spousal support?
Yeah, that depends on where you are in the proceedings. If it's brought within divorce proceedings, then that's dealt with under the matrimonial causes ordinance.
Right.
But there are provisions under those under the other ordinances for spousal support. So under the domestic proceedings ordinance, a freestanding application for spousal support can be made, and for child maintenance can be made.
And the divorce?
Well, no, that's not within divorce. That's just, so if the parties have separated, the
Right.
wife can still come back to the court under the domestic proceedings ordinance and ask
Oh,
for
okay.
spousal maintenance and or child maintenance.
Right, okay.
And child maintenance, spousal maintenance can be made under the family law ordinance as well.
But after a divorce, the wife cannot ask for, ex-wife cannot ask for spousal support?
No, well, spousal support will normally be dealt with within the divorce proceedings.
Right, right.
And the way that the court approaches that is generally to try to get them to a clean break situation. So there isn't an ongoing need for maintenance. But if there aren't sufficient assets within the marriage to do that, then you do have monthly periodical payments. Supreme Court, any amendment to that would generally come back to the Supreme Court. And I suppose this is where so I think I dropped out there. Am I back?
Yes.
Yes, you're back. You're
Yeah.
back.
That's where there was this dual overlap between the Magistrates Court and the Supreme Court for maintenance. But generally, if an order is made in the Supreme Court, it will stay there. But the Supreme Court will always try and get maintenance payments or spousal maintenance fixed, either on a clean break basis or on a basis where the parties know where they are going forward. So payments will be made until the child reaches an age of 18 or finishes full-time education or for a fixed term period. And there would have to be some relevant change of circumstances before the court will be willing to go back and have another look at that. So the Supreme
I have a
Court,
question. Oh,
yes.
sorry. I have a question, Justice Crucial. Can any order under the family ordinance be appealed, or?
Any court order can be appealed.
Than any ordinance.
So yes, but that would, assuming under the, we have pictures. Assuming under the if it's under the family law ordinance under the jurisdiction of the Magistrates Court, then yes, there is an appeal.
Thank you.
I see we have the Chief Magistrate joining us.
Just as to show, okay, one more thing. In terms of registry staff, and because they are the first persons that the general public would come in contact with, and they
Yes.
come and they file a claim or make an application in family matter, in a domestic matter. Sometimes they would come with just the name of the person they want to sue. So can you elaborate on the importance of getting full and accurate information before a matter is filed?
Do you not have
when
do
a
you not
matter is
insist
filed?
that you must have an address and a telephone number and an email? The difficulty that's going to happen with that is, I suppose this is more perhaps a question for the Chief Magistrate, because this falls under the administration of the Magistrates Court, which is under his remit. But the difficulty you're going to have is that if you simply issue a plaint note with somebody's name, how are they ever going to be served with it? And the difficulty that arises is that when you issue the plaint note, you're fixing a date for the hearing.
Yes, I understand.
So, I mean, I would have thought it was a matter of practicality that if people are bringing claims, they're going to have to provide details of where the defendant is and how they can be served.
The clerks that work at the registry, they could tell you that people want to fight with them all the time. If they come and have a name, they don't even have an accurate address, no phone number, no nothing, and they want to file their matter.
As I say, it's a matter for the admin of the Magistrates Court, but I would have thought as a matter of practicality, those claims can't be accepted.
I just want to touch on that, Justice Crucial. When my time at the registry, I used to stand firm. You don't have that information, your matter cannot be filed. Because
Yes.
you can have Sherry Brown, 5 different Sherry Browns. So
Yes.
without that backup information, which Sherry Brown are you to identify?
Well, as I say, I think it's outside of my remit. It's under the remit of the chief magistrate and the administration of
Yes,
the
yes, it
magistrates' court.
is.
But I don't
I'm
see
inclined to
how
agree.
you can be accepting claims if you don't know where the defendant is or how they're going to be served. It's a slightly different approach in the Supreme Court because you have, on the issue of a writ, you have 12 months in which to serve the writ. And the matter doesn't move forward until you can show proper service. With service in the magistrates' court, I mean, you help me. Generally, how is service affected? In my experience, is 9 times out of 10 there can be problems. The process doesn't get served.
Yes, that's I agree.
That's not really a legal issue; it's an administrative issue that the bailiffs or the process servers, have to serve these documents. But I can see, I mean, this raises the issue, I think, does it not, Ms. Aranda, that you raised with the ascendancy matters, that all of those claims are issued and they're fixed with a date for a hearing. And then if the complaint notes have not been served, then all those hearings become ineffective.
Yes,
And a massive amount of court time is wasted.
indeed. Any other questions?
It seems to me that it should be mandated that if you want to issue a complaint note, you have to give proper contact details for the defendant.
Yes, yes, it is.
And in the Supreme Court, as I say, that you get time to serve your originating process, but you still have to go on and serve it before that claim can be moved forward. You can then come back to the court and say, well, we've tried X, Y, and Z, and these are the reasons why we can't serve the defendant, but we know they have this email address, or we know they reside at these premises, but they're avoiding the process server. And different orders can be made for substituted service. But I think substituted service in the magistrates' court is very limited.
Yes, it is. Yes, it is.
Okay. Any other questions? Any other concerns? This is Gusho with care and protection. With care and protection. Can a person other than human services is to apply for care and protection?
The applications for emergency protection orders are made by the police or the director of social services. They're putting their names. I mean, it may well be delegated down to another officer for social services, but they are the people that must make the applications for emergency protection orders. So if you have, I don't know, an aunt or an uncle who's concerned, then they should raise those issues with either the police or social services.
Sorry, just discussion.
I think a lot of what we've talked about is perhaps administrative and procedural, and perhaps we should have had the chief magistrate on with this to get his take on it, because it does fall under his remit.
Okay.
Or perhaps that of the Chief Justice.
Thanks, Justice Gusho. Any other questions? Excuse me.
Nothing further?
I can say I don't have anything further. It was just a refresher of some things that I already know.
Yeah.
Yeah.
All right. Lee.
Right. Well, great stuff. So well, at least we finished half an hour early.
All right. Yes, Justice Gusho, I'll give a vote of thanks per se. Right, on behalf of Madam Chief Justice and the chairlady of the JEI, Judicial Education Institute, we would like to thank you on behalf of the support staff of the Magistracy and the Supreme Court. We would like to thank you, Justice Gusho, for sharing your knowledge with us. We hope that we will be able to use what you have imparted on us to improve in the services that we provide to the general court users, particularly in the civil jurisdiction of our courts. Thank you for the comparison of the role of each court, magistrate court and Supreme Court. Thank you for that, especially when it comes to the family matter as well, the initiating actions. Thank you for the references to the ordinances. I'm sure we'll be able to use it as a guide whenever we have certain questions. We know which ordinances to go to. So you were very helpful with regards to that. And once again, we thank you very much for your presentation.
Okay. Thank you very much. I'll speak to
All
you all
right.
soon, no doubt.
Sorry?
I'll speak to you all soon, no doubt.
Yes. All right. Thank you everyone for joining.
Hey, good afternoon.
Meeting is closed.
Thank you.
I think Antonio will be sending a evaluation